Good morning, everyone, and welcome to WorkCover Queensland's first common law webinar for 2023, where we will be discussing what employers need to do if they have a claim for damages. My name is Tim Loos. I'm a lawyer at WorkCover Queensland, and I'll be your host today. Before we get started, I'd like to acknowledge and pay respect to Queensland's elders past, present, and emerging. We thank the traditional custodians of country throughout Australia for their ongoing custodianship of land, waters, and community. Today's session will be recorded, and we will send a link to the recording out by email early next week. It will also be uploaded to WorkCover Queensland's YouTube channel. Please feel free to submit questions during the webinar using the panel on the right-hand side of your screen. If time permits, we'll go through the questions with our guest presenter at the end of the session. Your questions help us in planning future webinars for the year, so keep them coming, and also your feedback about the webinar. Okay, today's guest speaker is Cameron Seymour, partner at Mullins Lawyers. Cameron was admitted as a solicitor in 1990. He's practiced extensively in torts law, became an accredited specialist in personal injuries law in 1998. Cameron joined Mullins in 1999, where he's been a partner since 2000. He practices primarily in workers' compensation, public liability, and compulsory third-party claims. Cameron's also been a contributing editor to LexisNexis's service Personal Injuries Queensland since 1999. He sat on the Queensland Law Society Personal Injuries Conference Planning Committee, the Queensland Law Society Accident Compensation Tort Law Committee, and he's presented or chaired at various Queensland Law Society symposiums, and he delivers seminars to clients and the professional of personal injuries law. Welcome, Cameron, and thank you for taking the time to present today. Today's topic, it is something we've touched on in a webinar sort of around this time last year, but we think it's an important topic for us and for employers, and it's a really good way to start off this year's webinar series. Before I hand over to Cameron, I'd just like to remind our listeners that any information provided today in the presentation or in response to questions by WorkCover or Cameron or Mullins is general information only and should not be taken as legal advice. Okay, that's all from me for now. I'll pass over to Cameron to talk more about employers assisting during damages claims. Thank you, Cameron.
Thank you very much, Tim, and good morning, everyone, and welcome to the webinar. As Tim said, my name's Cameron Seymour, and I'm a partner at Mullins Lawyers and the practice group leader of the insurance litigation and personal injuries team there. And I've been advising WorkCover since 1990, and I've got the gig with you today. I know there are some employers who I normally deal with who are listening today, so a fond hello to you. The topic of this webinar is employers' obligations to assist WorkCover in damages claims. Now, WorkCover Queensland, as you I'm sure know, is the workers' compensation insurer for the vast majority of employers in Queensland. And every year, WorkCover handles about 90,000 workers' compensation claims, and around 4,000 of those claims become damages claims. An injured worker can recover damages against the employer insured by WorkCover over and above the compensation they received if they can prove the injury occurred as a result of the employer's negligence. Now, there's a few myths and misunderstandings on the issue of what an employer must do to assist WorkCover investigating a damages claim. So this is a good opportunity to shine a light on what are the employer's obligations, why does the employer have those obligations, what information and documents are relevant, how are those investigations undertaken, and what is the benefit of site inspections by WorkCover. So first of all, what are the employer's obligations? Section 280 of the Workers' Compensation Rehabilitation Act says that an employer against whom negligence is alleged in connection with the claim must cooperate fully and give WorkCover all information and access to documents in relation to the claim that WorkCover reasonably requires. Workers' compensation insurance is statutory insurance, which means it's mandated by the government in statute. The Workers' Compensation Rehabilitation Act is the statute that governs workers' compensation claims and damages claims. And damages claims are also sometimes referred to as common law claims. And the first version of that statute in Queensland came out in 1916. So this regime of workers' compensation and damages claims regulated by an Act has been around for over a century. And rather than having a printed insurance policy like you might have with a commercial insurer, for example, with your public liability insurance, the terms and conditions of the policy aren't set out in a leaflet or a brochure. They're set out in the Act, the Workers' Compensation Rehabilitation Act, and the regulations to that Act. So the obligation set out in Section 280 that I just referred to before is very similar to an insured's obligation to cooperate with their insurer. I'll read it again. In Section 280, it says that an employer against whom negligence is alleged in connection with the claim must cooperate fully and give WorkCover all information and access to documents in relation to the claim that WorkCover reasonably requires. Now, in commercial insurance, such as your public liability insurance, the insurer and the insured have a mutual obligation. The Latin phrase that describes it is "ubere fide." That's Latin for the utmost good faith. And the statutory version of that is set out in Section 280, which I just mentioned before. So what happens if an employer does not cooperate with WorkCover and provides all the information and access to documents that they need to? Well, that's set out in Section 280 of the Act as well. That says that WorkCover may recover from the employer as a debt in the Industrial Magistrates Court any additional costs reasonably incurred in connection with the claim as a direct result of the employer's non-compliance, and to the extent that WorkCover's interests in connection with the claim have been prejudiced as a direct result of the employer's non-compliance, an amount reflecting the extent of WorkCover's prejudice. So there are cost consequences involved if employers don't cooperate fully. And to put those cost consequences in perspective, using an example, if the employer has evidence which would prove they are liable in a claim, but don't provide that evidence to WorkCover, and the matter proceeds to trial and that evidence is tendered at the trial by another party, and the claimant wins their case because of that evidence, WorkCover may recover from the employer the costs of litigation, because litigation would not have been necessary if that information had been provided in the first place. Those costs could exceed $100,000. Similarly, if the employer has some information or documents which would prove the defence of the claim and does not disclose the information or documents, and WorkCover pays out the claim when it didn't have to, WorkCover can recover the costs of those damages, which again could be several $100,000s. Now, you might wonder why an employer would not willingly share evidence with WorkCover which could defend the claim. Well, there may be decision makers in an employer organisation who are sympathetic to the claimant, particularly in a family relationship, and particularly if both the claimant and the employer representative may benefit financially from the claimant's success. And to use a basic example, but a real example, if a mother and father run a business and their daughter works there, and the daughter twists her knee playing netball on the weekend, it may be tempting for the parents to say, oh, look, you come into work and we'll say that you injured yourself at work, and that way we'll get WorkCover to pay for the surgery that you need. Well, if that happens and that's found out, then you'll be paying for a lot more than the surgery. It may be the case also that some employers, particularly with no experience in damages claims, thinks that it serves their purpose and WorkCover's purpose, that is, they're doing themselves a WorkCover favour, to only provide information or documents that can be used to defend a claim, rather than show that the employer is in fact liable. Or even worse, and sometimes this happens, an employer may be tempted to manufacture evidence or say things contrary to the true state of affairs to persuade WorkCover to defend a claim. Now, that's not WorkCover's purpose at all. WorkCover's purpose is to balance the interests of the injured worker and the employer. And in damages claims, that means understanding the true facts of the claim, defending it if warranted, or otherwise paying it out. Now, inevitably, if there is evidence which is concealed or not made available, that evidence will come out eventually. And when it does, the delay will not be construed in the employer's favour. In fact, the court will take a very dim view. There are lots of checks and balances and review opportunities by many parties during a claim. And the injured workers' lawyers, the claimant's lawyers, will be very diligent in their own inquiries and will turn up witnesses that will flush out concealed information. And what no one wants to happen is for the true facts to be discovered during a trial rather than 2 years earlier when the damages claim was first made. All right, so why does the employer have an obligation to assist WorkCover? And as I said before, the damages and compensation claims are governed by the Workers' Compensation Rehabilitation Act. And damages claims particularly are governed by Part 5 of Chapter 5 of that Act. And Section 273, in Part 5, Chapter 5, says the object of Part 5 is to facilitate the just and expeditious resolution of the real issues in a claim at a minimum of expense. So important words in that sentence are just and expeditious, resolution of the real issues, and at a minimum of expense. And all those words are self-explanatory. That is, let's get to the point quickly, without undue cost, and if you can, resolve the claim. Section 274 of the Act sets out the overriding obligations of the parties. That's the injured worker, WorkCover, and the employer. And it says that in accordance with the object of this part is to be applied by the parties to avoid undue delay, expense and technicality. And the parties impliedly undertake to other parties to proceed in an expeditious way. And a court may impose sanctions if a party does not comply with the provision of the part. So you can see that if a party doesn't proceed in accordance with the just and expeditious resolution of the real issues in the claim at a minimum of expense, an aggrieved party may apply to the court for an order compelling the other party to act in a certain way or punish the other party to pay costs associated with their default. So the next thing we're going to talk about is who does the panel lawyer represent? And employers ask me all the time, you know, Cameron, who are you acting for? Are you my lawyer? You know, are you a good guy or a bad guy? And to explain in a damages claim, starting from the basics again, WorkCover is the employer's insurer, and WorkCover engages its own lawyers, including me, to investigate the claim and liaise with the employer. The employer can share and must share all relevant information with WorkCover's lawyer, that is, for example, me. But only WorkCover can instruct its lawyers to take any steps. But WorkCover requires its lawyers to involve the employer in each step of the claim, explain the process and the outcome so the employer properly understands the claim. That includes understanding the allegations made against it, understanding the evidence and what evidence is relevant, understanding the legal principles that are involved, and as well the legislative, policy and ethical frameworks within which the claim needs to be conducted. So we'll move on to those frameworks that shape how WorkCover, lawyers such as myself and employers are required to act. So the Workers' Compensation Rehabilitation Acts and Workers' Compensation Rehabilitation Regulations are the primary legislation which applies to workers' compensation and damages claims. Now, there are many other pieces of legislation which apply to certain extents, such as the liability for claims. You find that in the Work Health and Safety Act, and there's specific legislation which applies to specific industries, for example, electrical, maritime or mining industries. And there are various codes of practice published by government departments which apply to attempt to reduce the risk of hazards in the workplace. And once a damages claim is litigated, the court rules apply, which dictate procedures which apply. And as per the legislation, if those court rules are violated, a court can make orders compelling certain steps to be taken and costs to be paid. There's also something known as the common law, which is all the cases decided by the courts on similar matters, which create precedents and guidance on how to interpret various pieces of legislation, interpret court rules, interpret codes of practice, etc. Now, WorkCover Queensland, as a government insurer, is obliged to act as a model litigant due to the overarching principle: the power of the state is to be used for the public good and in the public interest, and not as a means of oppression, even in litigation. Model litigant principles which WorkCover must observe include dealing with claims promptly and not causing unnecessary delay in the handling of claims and litigation, endeavouring to avoid, prevent and limit the scope of legal proceedings wherever possible, including by giving consideration in all cases to alternative dispute resolution, keeping the costs of litigation to a minimum, paying legitimate claims without litigation, not requiring a party to prove a matter which the state, that is WorkCover, knows to be true, and not contesting liability if WorkCover knows the dispute is really about the value of the claim, not whether the incident occurred or whether the employer is liable. The solicitors acting for WorkCover also have their own ethical obligations of the legal profession. Those ethics compel the lawyer, as an officer of the court, just sidetracking for a moment, when a person is admitted as a solicitor, you have to actually pledge an oath to the fidelity of the court, saying that you will uphold all the ethical obligations first and foremost. So as an officer of the court, I'm obliged to uphold the rule of law and act fairly, and recognise that my primary duty is actually not to my client, but in fact to the court itself. So for that reason, a lawyer can't say something they know to be untrue, and ideally should test the truth of any evidence they rely upon. And I can't mislead the court through silence. So sometimes an employer might say to me, but hang on, you're my lawyer, you need to defend this claim. But it's not as simple as that. First of all, I'm WorkCover's lawyer. And secondly, WorkCover can only ask me to defend the claim if it's worth defending. And there may be occasions when an employer will give me instructions on what's happened, and I'm obliged to say, well, can you show me, can you prove that? Can you show me why you say that? Is there a document? Who can I speak to verify that? And that's just lawyers doing their job as they're meant to do it. So I think we've come to the point where we can accept that when a claimant makes a claim for damages, WorkCover must respond promptly to investigate the claim, to ascertain its prospects of success, and act accordingly. And that requires the employer's cooperation. It can't be done without the employer's cooperation. So the question is, how does an employer assist WorkCover to investigate a damages claim? And the answer, obviously, is providing all relevant information and documents. Now, my practice, and probably the practice of most, if not all, WorkCover panel lawyers, is to make contact with the relevant employer representative very shortly after a notice of claim for damages is served. And I send a copy of the notice of claim to the employer, and I summarise the important aspects that are set out in that notice of claim. And I invite comment regarding the circumstances of the claim and request evidence in the form of informational documents about the claimant or the circumstances of the incident causing the injury, the extent of the claimant's impairment, and the damages, the heads of damage they are seeking. Depending on the size of the employer, those documents might come from a variety of departments and sites. And you can imagine that small employers might have one or two people that run the entire business, and there's probably a folder of documents in the top drawer somewhere. When you compare that or contrast that to a very, very large employer, they may have a number of different sites, a number of different personnel in a hierarchy that is each charged with doing their own tasks and jobs that sort of intertwine with the compensation claim, and you may be hunting for documents from a myriad of different departments. The nature and the extent of the obligation on the employer to disclose information or documents is set out in section 279 of the Workers' Compensation Rehabilitation Act. And just for the time being, if we limit those obligations to the pre-litigation process, just to explain that there's a before litigation process, then if a claim doesn't resolve during the pre-litigation process, it becomes litigated. But thankfully, about 85% of damages claims are resolved without having to commence litigation. Section 279 of the Act says that the employer must cooperate by giving each other, that's the claimant's lawyers, first of all giving to WorkCover's lawyers to then pass on to the claimant's lawyers, copies of relevant documents about the circumstances of the event resulting in injury and the worker's injury and the worker's prospects of rehabilitation, and giving information reasonably requested by each other party about the circumstances of the event, the nature of the injury, any impairment or financial loss, medical treatment, rehabilitation, the worker's medical history, and applications for compensation. WorkCover is required to provide copies of those relevant documents to the claimant's lawyers within 21 business days after the claimant serves their notice of claim, but that obligation continues after that date. Now, it's not often that we always get those documents or information within 21 business days, which is why that obligation continues. And it continues up until the time that a court either makes a decision or the claim is settled. It's the job of WorkCover's panel lawyers to help employers identify certain documents, which might also put them on a train of inquiry, which then might lead to further requests for information or documents. So it becomes a sort of, sometimes a never-ending process. Now, once a claim is litigated, and as I said before, 85% of claims aren't litigated, so of the 15% of claims that may end up in litigation, there's an extra layer of investigation imposed by the relevant court rules, which expands the class of documents and the obligation of disclosure and cooperation even further. And that requires a solicitor at WorkCover's lawyer to personally certify to the court that the duty of disclosure has been properly explained to the employer and carries further sanctions and penalties if documents aren't provided by the employer. So during litigation, it's almost as if the whole process of disclosure starts again, and that's because the court rules have a wider duty of what documents might become relevant. And we can't just assume that because documents or information was disclosed during the pre-proceedings process, that everything's been covered off during the litigated process. So you'll just have to bear with WorkCover's lawyer if a matter becomes litigated and they ask you questions that are similar but not the same as the ones that were asked during the pre-proceedings process. And look, I understand and appreciate that employers may be frustrated due to multiple requests for information or documents. You know, you've got better use of your time running your business, but these are legal obligations that are on employers. And as I said before, sometimes receipt of some information or documents prompts further investigations undertaken by WorkCover's lawyer. And at the same time, the claimant's lawyer may make their own requests for information or documents, which might be slightly different. And those requests need to be responded to as well. And if they're ignored, a court may impose a sanction. So, as I said, I get your frustration, and the best response to that is to try and give WorkCover's lawyers as much as they can at the outset, rather than drip feed on subsequent occasions. And if you can be put on notice when a person brings a compensation claim that there's some possibility that it might end in a damages claim, if you can just corral all your documents and get all your investigations together and put it together in a file, so that once the matter, or if the matter does become a damages claim, you've got everything there and you can just pass it on to WorkCover and their lawyers. That might save you a bit of hassle down the track. So how are investigations undertaken apart from just providing documents or information to WorkCover's lawyer in one big go at the beginning? Well, those investigations can be undertaken in all sorts of ways, but most commonly during the process of phone calls and emails and letters between WorkCover's lawyers and the employer. Sometimes investigations are conducted by correspondence or on-site by specialist investigators, known as factual investigators. There's a few that WorkCover panel lawyers use, and they will physically come to your site and liaise with you and engage with you and tell you all about the claim and the sort of documents they're looking for on instructions from WorkCover's panel lawyers, and sit down with you and go through the filing cabinet with you and get it all together and interview witnesses, take statements, and then provide a report to WorkCover's panel lawyers. Now, some investigations are conducted on site by WorkCover's panel lawyer, particularly if a specialist investigator isn't appointed, or there may be a combination of all those things. There may be specialist investigators and WorkCover's panel lawyers, and emails back and forward and phone calls, because the object, as I said at the beginning, is to make sure that the panel lawyer understands the true situation of what actually occurred, and that requires a lot of digging. Now, quite often, as I said before, the employer may have already conducted its own investigation into the incident. It may have opened the file containing the incident report and all the investigations, maybe statements, photographs, videos, medical certificates, correspondence with WorkCover, correspondence with the injured worker, which these days it's quite often texts, plus return to work plans and documents relevant to sick leave, payroll, etc. That's great. As I said before, keep them all together, pass them on to WorkCover, because otherwise that's exactly the sort of documents that I'll be asking for anyway. So these documents need to be provided to WorkCover's lawyers, and WorkCover's lawyers will go through those documents and decide which documents are required to be disclosed. Documents won't be disclosed if they're not relevant to the claim or fall outside the ambit of what the Act says is disclosable, or if they're protected from disclosure through privilege, or if disclosure might assist the claimant in the furtherance of a fraud. But that decision is for WorkCover's lawyer to make rather than the employer. So the employer shouldn't be tempted to think, oh, well, this isn't relevant, or if I disclose this, it's going to sink any chance I've got of defending the claim, or it might be, someone might look at me adversely because it demonstrates a practice that shouldn't have occurred. You shouldn't be thinking about that. You need to pass it on to WorkCover's lawyer, and WorkCover will act in accordance with the Act and ethically, and assist in resolving the claim where possible, or defending the claim where it should be defended. Now, as I've said, that WorkCover's lawyer is required to disclose documents that are disclosable, and the lawyer is ethically bound to disclose it, despite any protest, or protest from the employer perhaps, because the employer is not the lawyer's client, it's WorkCover who's the lawyer's client. And the lawyer's primary duty is to the court and to operate faithfully within the legal and ethical framework that I've discussed. But generally speaking, advice given about the claim by WorkCover's lawyer to the employer is not required to be disclosed. So, for example, if a worker is injured because they're standing next to a fan in a factory working and the fan doesn't have a guard on it, and the worker turns around and cuts themselves on the fan, and they cut their finger off. If there's CCTV that shows that happening, that's got to be disclosed to WorkCover's lawyers and then to the claimant's lawyers. But if we say to the employer, look, we're not going to be able to defend this case because it's quite plain that there was a danger there that was waiting to happen, that advice that we give isn't disclosable. So that's just between the employer and the lawyer and WorkCover. So we have to disclose the CCTV because that's factual. We don't have to disclose the advice. But we wouldn't be able to deny that the claimant cut themselves on the fan, and we would probably try to settle it for its proper value. Because as I said before, WorkCover's lawyers can't conceal, and we can't allege facts that they know to be true. So we can't say the fan was guarded if it wasn't guarded. And we can't say that the claimant didn't cut his finger on the fan if we know that he did. And really, if you think about that, that's just eminently sensible. Otherwise, people would be resisting every single claimant. And all that does is adds to the cost and money in the pocket of the lawyers rather than in the pocket of the person who deserves the compensation or damages. Now we come to site inspections, which is a bit of a favourite topic of mine because I do attend site inspections quite regularly, and I always find them to be of great benefit, particularly as a circuit breaker when there's a bit of a conflict between the parties. So from time to time, particularly if a specialist factual investigator isn't used by a WorkCover's lawyer, the lawyer themselves may attend a site inspection at the employer's premises. And this may be because the claimant's description of the incident isn't clear and the panel lawyer just doesn't understand what happened or how it happened. Or the employer's description of the incident involves technical terms which aren't readily understood. The employer may tell me, look, he was overriding the reflux valve in the atrium turn. And I'm like, I'm sorry, I've got no idea what that means. So a picture is worth 1,000 words. Show me what was going on, and then I'll understand it. And sometimes the employer is just adamant that the incident could not have occurred in the manner described, and I'll have to go out and have a look at it and maybe find an explanation that's somewhere between the claimant's explanation and what the employer understands, which is probably going to be what actually happened. Now, as mentioned at the outset, the objects of the governing legislation and the model litigant principles require efforts to be made to resolve disputes early and avoid litigation where possible. And in the circumstances where each party's understanding of how the incident occurred can be improved by a site inspection, I certainly recommend it. Sometimes a site inspection can prove to the employer that the incident could have occurred. Now that's a benefit to the employer because then the employer can take steps to improve safety in the future. If it discloses a chink in the armour or a gap in the system that the employer hadn't thought about, then forewarned is forearmed and that can be fixed. And that's a good result. And sometimes the site inspection can prove to the claimant's lawyer that the incident could not have occurred. And as far as the employer is concerned, that's a great result as well. But even for the claimant's lawyer, that's a great result because they can work that out at the beginning rather than after charging their client tens of thousands of dollars or hundreds of thousands of dollars on a claim that was never going to go anywhere in the first place. Now, either way, it's beneficial to determine that early in the claim, rather than proceeding on the basis of a mistaken premise. So, in my experience, when employers and claimants dispute each other's versions, it's because the claimant's version hasn't been properly understood or accurately articulated by their own legal team. And that may be because there's an inexperienced paralegal who drafted the statement, and that goes through to the notice of claim, and the misunderstanding has been perpetuated from the beginning. And sometimes, as WorkCover's lawyer, it's very frustrating that the correct version of what actually happened might only be set out at the compulsory conference 6 months or 9 months after the notice of claim has been served, after the injured worker's barrister has had an opportunity to have a comprehensive conversation with the claimant. And you're met on the day of the conference with their barrister saying, look, I'm really sorry, it didn't happen as is set out in question 40. It happened like this, and the reason for the mistake is that. And then, if I'm sitting next to the employer at the conference, the employer will go, oh yeah, that's probably what happened. And then you deal with the issue then. So that, unfortunately, that does happen from time to time. Alternatively, there might be dispute in the version because the claimant's just inexperienced. Might have only been on the job for a couple of days and they used the wrong terminology. They said they were standing or working the B line instead of the C line. And because they've said the B line, the employer's gone, well, that doesn't happen on the B line, and it's not until they've worked out that they were actually in the C line that everything comes together. There might be a dispute in the versions because the employer provides WorkCover's lawyers with instructions on how a task should have been undertaken, rather than how it may have been undertaken. And often there can be quite a difference between how a task may or is undertaken compared to how it should be undertaken. Or similarly, along the same vein, an employer hasn't considered an intervening event which isn't part of the usual process, which adversely impacts the task at the critical time. And it's quite often that there might be a safe work method statement, and provided that everything goes along fine, that should be adhered to. But if there's a spanner in the works, literally or figuratively, and something changes and people sort of adapt on the spot, then that opens the door to a lot of risk. And it's sometimes the case that an employer doesn't comprehend that or understand that might have happened on the day, and it's therefore giving instructions on what should have happened rather than what might have happened because of some intervening event. And sometimes, it's just the case that an employer doesn't want to admit the possibility of a mistake because they might feel that they might be open to attack or feel a bit of shame about it, but really shouldn't be worried about that. That's why we've got workers' compensation, is to cover those mistakes or errors. It's important to note that courts aren't terribly interested in how tasks are usually performed, but they're extremely interested in how the task was performed at the time. Because a lot of the time the judge is looking at the person and the employer might be giving evidence about how safe the system is, and the judge would be thinking, well, surely it couldn't have been safe on this particular occasion because otherwise why did the fellow have his finger chopped off? So they're really interested in what happened at the time, and we need to go to what happened at the time rather than using generalities as to how things usually occur. And I can tell you that many of my site inspections have involved scenarios just like this. The claimant will say in the notice of claim that he was required to repetitively lift weights of 20 kilograms in a bending and twisting motion, and you can understand that would probably cause a back injury. And the employer instructs that, well, that can't be right because the maximum weight lifted can't exceed 10 kilograms and it doesn't involve a bending or lifting motion. So I go out, I attend a site inspection, and immediately I see workers lifting objects weighing 20 kilograms in a bending and twisting motion. And the employer's response to me will be, well, yes, but they shouldn't be doing that. And I go, okay, well, they shouldn't be doing it. Clearly they are. If they shouldn't be doing that, can you show me evidence of the training or the instruction that's provided to them so they know they shouldn't be doing that? And then there's no evidence of that training or instruction. So, you know, that's fairly common, and you know, don't feel bad if that may have happened to you, because it's, you know, as I said before, it is quite common. I can give you some other, I mean, time commits me at the moment, to give you some other examples, and you might just be able to reflect on whether any of these examples might apply to you. And these are all fairly recent examples. With one employer, I was told that the maximum weight of something lifted by its workers was 7 kilograms, and that these objects were lifted one at a time. And I went out to the site and I saw the object, and I said, well, you know, is that it? You know, do you mind if I lift it? And they said, no, go ahead. And the objects were stacked in such a way that they hooked onto one another. So when I lifted the first object, I actually also lifted the second one underneath it at the same time, because they were hooked together. So a 7 kilo lift turned into a 14 kilo lift. That's actually fairly common. I've been to another premises where these large metal pieces of metal mesh were required to be physically transported from one section to another. They weighed about 10 or 15 kilos each, but when you lifted them, it's very easy for the mesh to be hooked onto each other. So all of a sudden, the 10 or 15 lift turned into a 20 or 30 kilo lift. I've been told that a particular worker on a production line could not have been lifting any weights above shoulder height. And when I've gone out there and invited the claimant's lawyers to go out there, I saw all the workers on the production line, and yes, they were lifting at sort of waist to chest height, but they were all 6 feet tall and the worker was 5 feet tall. So that particular worker was lifting above shoulder height. I've been out to inspections where heavy trolleys have stopped suddenly and jolted their backs and shoulders. And I've been told that that just doesn't happen, and the trolleys have all got clean wheels, and the wheels are all good, and there's no debris on the floor or anything like that. And I've gone out and I've pushed a trolley that's stopped at a raised edge on the floor or got stuck in a gap. And, you know, immediately just showing the employer, well, look, you know, I've been doing this 5 seconds and already I've got this trolley that's not moving. And perhaps the most classic one was a worker who slipped over on a greasy floor in a restaurant. And I was told that it's just impossible, could never have occurred, because the floors are washed and mopped, you know, several times a day. And on the occasion I went out, I was virtually skating on the floor, and you could see my skiddy footprints all over the floor. And yet, despite that, the employer told me that it wasn't greasy and could never have happened. So, you know, it is the WorkCover panel lawyer's job to go out and check things for themselves, and that's a good thing. And the sooner we can work out what's happened, and the sooner we can explain to the employer that the benefits of working that out at an early stage, then the better it is for everyone. Now, there are other ways that employers can help themselves and help WorkCover. As I previously mentioned, WorkCover's primary stakeholders are the employers and the injured workers. And any step that might be taken to benefit the employer and the injured worker is definitely a win-win scenario. And rehabilitation is one of those win-win scenarios. Rehabilitation of injured workers is a fundamental duty of WorkCover Queensland, and the Workers' Compensation and Rehabilitation Act and the regulations set out the obligations on WorkCover and employers, and particularly with large employers. Large employers must appoint a rehabilitation and return to work coordinator. And if you're wondering what a large employer is defined as, technically speaking, if an employer employs workers in a high risk industry and in the preceding financial year paid wages of over $4.3 million, or if not employing workers in a high risk industry paid wages over about $8.7 million, that's taken to be a large employer. So they must appoint their own rehabilitation and return to work coordinator to implement the employer's rehabilitation policies and procedures and provide rehabilitation to injured workers. And regardless of the size of the employer should support WorkCover's rehabilitation processes. And whilst the topic of rehabilitation is big enough to have its very own webinar, it's important to observe why rehabilitation benefits employers. The longer an injured worker is away from work, the more likely it is that the worker will bring a damages claim. And we know that. We've got statistics that prove that. If a personal relationship between an employer and an injured worker breaks down, again, it's more likely an injured worker will bring a damages claim. We know that. There are stats to support that. If an injured worker is successfully rehabilitated, that will reduce the duration of the compensation claim and preserve the personal relationship between the injured worker and the employer, and thus that should decrease the likelihood of a damages claim. If the injured worker is successfully rehabilitated and a damages claim is brought, future economic loss is likely to be less than with a non-rehabilitated worker, because the workers return to work, and it will be more difficult to make an argument on behalf of the injured worker that they can't work or their capacity to earn income has been diminished. Now, the less damages claims that are made and the lower the damages, the less impact on the employer's workers' compensation premium. That's definitely a benefit. Now, we've just about reached the end of my part of the presentation subject to questions. So just to recap a few things, workers' compensation insurance is compulsory for employers, and it has been in Queensland for more than a century. It exists so WorkCover pays claims out of revenue received from consolidated premiums and investments, so employers don't have to pay out the claims from their own pockets. An employer owes a worker a duty of care to take all reasonable steps to minimise the risk of injury to a worker in the course of their employment, and the employer's duty of care is a high one. Legislation, WorkCover's policies as a model litigant, and the duty of WorkCover's lawyers to act ethically as officers of the court require prompt disclosure of information and documents relevant to issues in the claim, and it benefits all parties to investigate claims at the earliest opportunity. If you don't understand why a document or information is disclosable, or you don't understand the investigation process, you should ask WorkCover's panel lawyer to explain it to you. Employers should always be willing to work with WorkCover to rehabilitate injured workers to achieve the goal of returning an injured worker to work and minimising the chance of damages claim. Lastly, WorkCover needs to balance the interests of the employer as well as the claimant, which can sometimes be a difficult balancing act. If an employer is not satisfied with WorkCover's lawyer's explanation on an issue, the consequence of it, the employer can raise the matter with WorkCover, and WorkCover is very keen to assist employers understanding the process, which is demonstrated by the regular webinars that WorkCover presents, such as this one. So I hope that you've had some takeaways from that. Maybe you've learned something new or had something confirmed to you, just giving you a better feeling of what's involved. And I'll now hand back over to Tim, who may have received some of your questions, and we can work out how to best address them.
Thank you, Kim. We've had a few come through in advance, and we've had a few come through while you were speaking, so we'll do our best to get through some of these now. I'll start off with one of the ones that came through online prior. So in the initial stages of a common law claim, should an employer get legal representation as well as WorkCover's lawyers?
It's probably not necessary, and I think that all it's going to do is increase your own costs because you'll have to pay for your own lawyers. As we've discussed in this presentation, if you've got a document that's relevant, it must be disclosed. It must be disclosed to WorkCover's lawyer. And if you've got another part of that process going through your own lawyer before it gets to WorkCover's lawyer, you're either paying your own lawyer out of your own pocket to do something that you don't need to do, and if that document is not disclosed and comes out anyway at the end, and you've been advised by your lawyer not to disclose it because you've been given wrong advice, then WorkCover has the ability to recover the costs that it had to pay extra from you, and you might be then looking at your own lawyer and asking them to repay that to you. Generally speaking, it's not necessary. There might be one or two occasions where you think that it might be a benefit. Your own lawyer may act as a facilitator to WorkCover's lawyer if you're not sure of how to go about things. But in the first instance, I would encourage you to liaise directly with WorkCover's lawyer.
Yeah, and WorkCover itself, if you've got a relationship manager in the claims area or whoever you've been dealing with over the statutory claim, feel free to call that person up and ask questions as well. The next one that came in advance, can the law firms push for WorkCover to do surveillance where plaintiffs have raised suspicions?
That's a really, really interesting question, and it's something that I discuss with employers quite often. I have to say that surveillance isn't as common these days as it has been in the past. There are a lot of privacy considerations to be applied these days, and WorkCover has its own internal policy that is a tool to be applied in deciding whether surveillance will be undertaken or not. Certainly an employer can suggest to WorkCover's lawyer that a particular claim might be a good candidate for surveillance and set out the reasons for that. And WorkCover's panel lawyer will then go to WorkCover and applying a policy say, this is a claim where we think surveillance should be undertaken. But in the end, it's WorkCover's decision to decide whether surveillance will be undertaken for privacy reasons, or it may lead to an adverse result which only confirms the claim rather than defends the claim. But certainly, just to answer the question, can the employer push for it? The employer can push for it and send up to the panel lawyer to seek those instructions from WorkCover, who has the final say.
Thanks. The next question we'll go to, actually I think I've seen this come up in every webinar we've done. It's sort of a hot topic, but where workers don't disclose pre-existing injuries or illnesses to the business, so they're not aware, and then they aggravate something pre-existing, and then the employer ends up with a damages claim against them. The question here is about the obligation on the worker to disclose first, but perhaps if you talk about how that's handled generally in a damages claim with medical evidence.
This probably, again, might be a topic for its own webinar.
Yeah,
it's such a spectrum. Nearly every person over the age of 20 has got some sort of pre-existing condition and or a weakness somewhere in their body, and a lot of the time, we manage that and we go about our business quite successfully whilst being able to manage it. So if a person has a pre-existing condition that's of that nature, are they obliged to disclose it? Well, they might argue successfully that they're not obliged. They might not understand at the time that they're applying for the job, what the tasks that they'll be asked to do actually entail. Sometimes it's just from the employer a vague or general question which isn't specific enough, and the employer will later argue that the worker didn't specifically address the issue, and that might be because they weren't specifically asked it. So there are so many facets to this. I think from an employer's point of view, it would be very, very helpful if you did have a written checklist that asked a person to check whether they had, in the last 6 months or 2 years or 5 years or whatever, been treated for an injury or a condition and then check out the part of the body. So what that does is it commits the worker to an answer which you can then raise with them later on, or WorkCover Lawyers can raise with them later on. And then you should almost go through the checklist with them and say, is this right, is this right, is this right? Now, in that situation, if you find out that someone's had surgery to their back 6 months before and the task involves manual handling that they weren't fit to do, then yes, you've got a very good case. But that's at one end of the extreme. So, as I said, there's a massive spectrum that's involved here. But the more effort you put into protecting yourself with documents and going through the documents with that person and making them understand what the task that they're going to undertake includes, and provided that you've got your own safe work systems and people within the organisation that can help the person train to do the task the right way, that will help you later on.
You mentioned in the course of your talk that a lot of communication is done by text these days, and someone has asked how do they provide text messages as evidence, I suppose? So do you take a screenshot of the text, or do you just jot it down and pass it on? What's the best way to save and provide that information?
This might be a question that's better answered by an IT expert, but as far as I'm concerned, and I'm not the doyen in relation to this, I just use screenshots. So yeah,
I've seen that.
Yeah,
the most common.
Yeah, don't delete them from your phone. But if you're going to trade in your phone and upgrade, and you're worried that it might be lost, what I would do is take a screenshot, put it in a paper version, and stick it in a file somewhere, or an electronic version of screenshot, stick it in an electronic file somewhere, so that if for some reason it does disappear from your phone, there's some other version of it somewhere.
Right, excellent. We're just about out of time, and there's a few more questions here. I'll just try and touch on a couple of them. There's one here saying, asking if there are any circumstances where the employer, WorkCover, or panel lawyers might start preparing for a damages claim prior to the not being lodged. That might be more of a question for WorkCover, but have you got experience yourself with that sort of thing?
Well, I know that there are some pilot programs within WorkCover where certain panel firms are alerted to the likelihood of damages claims being made before a notice of claim is filed, or served. Now, it's actually on WorkCover's conflict of interest policy that WorkCover's panel lawyers can't give advice to employers in relation to potential or anticipated damages claims, and can only give advice after a notice of claim is served. So whilst that is in the conflict of interest policy, that shouldn't stop a panel lawyer who acts for an employer just giving general advice in relation to how to generally minimise liability or exposure in relation to claims. But certainly WorkCover is aware that there is a benefit in dealing with some of these claims before they get too far ahead of themselves.
Yeah, that's it. There is a pilot program for certain types of claims at the moment where we can start looking into them early. But there's nothing to stop employers from sort of following broad steps that Cameron's talked about today, which is all really good information about what employers can do to sort of support themselves if there's been an injury in the workplace and the SAP claims on foot. You can start sort of hanging on to the information that's going to be relevant to defending or bringing issues to light. I'm conscious that we've just hit the time limit. There is one you can touch on very quickly, Cameron, just on time limit for bringing a damages claim.
All right. Well, the time limit is I wish you hadn't said quickly.
Sorry. There is a caveat.
But in Queensland, for a workers' compensation that becomes damages, it's a 3-year limitation period set out in the Limitation of Actions Act. However, if a person is under a legal disability, that 3-year period doesn't run until they're outside their disability. So, for example, if someone's under the age of 18, that's a legal disability, and the 3 years doesn't run until they're 18. If someone's incarcerated, they're under a legal disability, so the limitation period might run up after that. But there's an extension in Schedule 5 of the Act, which allows the primary limitation of 3 years to be extended even further in certain circumstances, and that has to do with when a notice of claim is served, a notice of assessment is served. So in those situations, the limitation period might be extended. And then if all else fails, the Limitation of Actions Act says that there is an ability to extend whatever limitation period might have applied until a period of 1 year after the claimant becomes aware of a material fact of decisive nature that they weren't otherwise aware of in the 1 year preceding the expiration of the primary limitation period.
That was excellent. Very concise summary. Thank you. Right, sorry if I didn't get to your question. We've gone over time now. I'll wrap it up there. Thank you very much for presenting today, Cameron. That was a lot of excellent practical information for employers and our listeners. To the audience, thank you all very much for tuning in this morning. I hope you found it helpful and informative. As I mentioned at the start, we've recorded this. It'll be sent out, the link will be sent out to you probably early next week. We'll also upload this to our general WorkCover YouTube channel, so feel free to watch it again or let your colleagues know about it. And you can find all our previous common law webinars there in a dedicated playlist. That's all from us here at WorkCover Queensland. We hope you have a great day. Keep an eye out for details of our next webinar, which will be sent out by email if you register for this one, or we'll put it on LinkedIn or on the WorkSafe website under the events page. So thank you all again. Stay safe and have a great rest of your day.